conclude the ninth case for today, 348487, Michigan Open Carry, Inc., the Department of State Police.
Afternoon now.
Afternoon.
It is, 15 minutes.
I'm sorry?
15 minutes.
Well, 15 minutes is about lunchtime for me here, so you've probably been hearing random coughs, and I think looking over in the courtroom, it's him and me. I've got a 2-year-old.
So keep your distance.
Yeah, so it's been 2-year-olds that bring home enjoyment things from daycare that I wish we could leave at daycare that
You're
way.
strengthening your immune system.
That's right.
Well, always a positive spin on that sad set of circumstances, so, but,
Judge Mariki's very positive.
apparently here. So I was going to say in the middle of the night last time when I thought my throat was going to burn out, a different story here. So, but I'm better this morning, but we're getting there. So I apologize for the coughing today if it's interrupted.
We've all been there and done that. So.
Your Honor, Philip Ellison appearing on behalf of the appellant in this matter. And Your Honor, I want to address this in two parts. And I want the court, if anything, to leave this oral argument with this premise. The problem that I have, and of course, looking back after 7 months since I've been sitting here with you guys, and you look back at the briefs, you say, I wish I would have hit on this part a little harder. I'm going to hit on this part a little harder right now. The CPL firearms database is not lean data. You have to take that, you have to start from that right off the bat. And I can support that right from the get-go with the affidavit of Kevin Collins, which came from the state police side of the matter. And that's at my appendix 63A through 65A. It's important because the sole basis on which the lower court granted summary disposition under I-2 to the state of Michigan was because it believed that this was either lean data or ran through lean coming forward, and therefore the prohibition under the Criminal Justice Information Systems Policy Council Act barred access to this. It's important because this is not lean data. This is a database, a CPL database is created by the Firearms Act, not by lean. We know lean. Lean is the system that's got our driver's license, our criminal history, God knows what they've got in there because we usually can't get access to it. But here what's important is that the data that my client is seeking, which I call the 5E data, that is a firearms database, not a lean database. And when I was trying to present how I would try to articulate this to the court, it would be in a parallel analogous circumstances if I was asking for Facebook data, right? You can access Facebook a lot of different ways. You can do it with your computer. You can do it with your iPad, which I see some of you guys have iPads up here. You can do it with your phone, which is my common way of doing it. My wife has got now an Apple Watch I don't even begin to ask, but somehow that watch is connected to Facebook as well. What essentially the state is arguing is that because they have rules about what data goes through an iPad, they shouldn't have to produce the data that's being pulled through the iPad, but rather it cuts off access to any way you can get to that particular database. The affidavit of Kevin Collins proves that the database is not in lean, but simply a useful tool to allow, for example, law enforcement officers, we know about the computers that are in their cars. Law enforcement, when they type in your lean, they can actually pull data, not from the lean database, but from the CPL database.
It's simply one of the conduits through which you can obtain the information.
Correct, exactly correct. And that you couldn't have said it better if I tried myself here. So
I'll send you my bill.
Oh, there you go, all right. Send a cough drop too while you're at it. But the key here is that the sole basis that both the state in their appellee brief as well as the trial court judge from the Court of Claims based this on was the language, which again is kind of fuzzy in and of itself, and I'll talk about that in a second, is that lean data this is lean data and therefore it is precluded from being accessed under the Freedom of Information Act through the pass-through exemption. That is wrong. That is wrong. Because the whole basis here is that this is if I can leave you with nothing else I say here today, this is the data that my client is seeking under 5E is not lean data. Now, switching gears, let's assume for the sake of argument that it is lean data because it conduits through lean. The language under Section 4 of the Criminal Justice Information Systems Policy Council Act, which I'm just going to call the Lean Act, it says a person shall not disclose information governed under this act in a manner that is not authorized by law or rule. Here, FOIA is that law. FOIA provides the ability to give access to that information. If we look at the Firearms Act itself, it specifically exempts things like the names of applicants, their addresses, their applications that they file, whether they have a CPL license or not. What it doesn't exempt, under the definition of a firearms record, is the 5E data. That data that says, hey, when the police officer wants to look up your CPL, not lien, your CPL database record, they have to give the reason why they're accessing it. That's the data that my client wants and is seeking.
Mr. Ellison?
Yes.
Does your proposition that FOIA, the State FOIA Act, creates the mechanism through which to operate, as authorized by law, to get this data?
Correct.
If that is the case, doesn't that then subsume all other statutory exceptions? For example, Health and Human Services says you can't disclose HIPAA data, et cetera, et cetera, et cetera, except as authorized by law. You can't do other things. You can't disclose juvenile arrest records, except as authorized by law. Wouldn't that exception then completely eliminate any exclusions that the legislative body has determined might be appropriate?
Well, the problem with that is that if, then you would look to the other exemptions under FOIA. For example, HIPAA would be would fall under the personal information, the 13(1)A, for example, okay? That would provide an alternative basis. But what's important here, and I guess I don't necessarily disagree with your premise, but the burden's not on me to prove that. Under Section 10(4) of the, subsection 4 of Section 10 of FOIA, the burden is on the government to assert the exemption, not me negating all possible exemptions going forward. So I guess I don't necessarily disagree with your assertion, but they would have to come back and say, okay, if you want HIPAA data, for example, this falls under this particular exemption this way. And I'm glad you pointed that out. Also, I would point to is if we look at the language of the pass-through, what we call the pass-through exemption, that's 13(1)D. The language of that says that it has to be records or information specifically, not generally, specifically described and exempted from disclosure by statute. So what's required in that respect is that you actually have to, the law itself that serves as the basis, if you're not going to be in one of the 20, I think it's 28 now, in the Section 13, you have to look to the underlying other law that says, is this specifically described and exempted going forward? Now, if we flip to the Law Enforcement Lien Act, right, it doesn't specifically exempt this data. The basis that they're asserting is an administrative rule. The case law that I pointed to.
What data exactly do you in your request seek?
We are seeking not, I guess let me make sure we're not asking first. We're not asking for any long way around, right?
Because I asked you, what are you not asking?
Right, sure. So lawyers, we take the long way around, right? So.
Well, get comfortable for the journey.
We are not asking for any data under the Firearms Act that is designated as confidential. What we are asking is the 5E data, and that is the actual reason why the law enforcement officer is saying, I need to search this CPL database for this particular reason. They input that, and as the Collins affidavit points out, that's then recorded, not in lien, but into the CPL database.
Okay, MSP responded to your request.
Yes.
And they gave a series of numbers, 4 digits to 10, not 10, but 4 to 7 digits.
Correct.
Or something. Why is that not responsive?
Because we were looking for the reasons that were inputted, not the number of times that it was inputted. They actually, because if you look at the response.
And then in response to the appeal, they say, we don't maintain that. We don't maintain a central database that has that.
Respectfully, I disagree. We need to look at Kevin Collins' affidavit. It is recorded, and they do record that data. Now, they have some pre-filled out fields that they can check a particular box of the common ones, but there's also one where they can actually input, if it's not one of those, they can actually input that data in there going forward. And as you can imagine,
So did you got the information with regard to the the ones that have the reasons that are commonly provided?
No.
You didn't get any of
We
that?
didn't get any of that. All we got was a list of numbers.
Okay.
okay? But it doesn't correlate, all they said is literally, A, some numbers, B, they didn't say what those numbers were, they didn't say anything about any of this
Those
aspect.
the letters didn't correlate with a,
Not that I could ascertain. That's the problem that exists here. Now, maybe if they had more clearly defined that aspect, but here's the important part. FOIA, they're asking for the records themselves. They're not asking for them to put those into a response letter.
but just to follow up on my question,
Yeah.
it then indicates, and thank you, Judge Rudd, for providing this, 1 through 7 with a bunch of numbers after it, and then it suggests going to the website for more detail related to the information provided above. If you go to that website, does it provide the linkage?
No.
No. So for number 4, 1,449,241, if I went to the website, there's no way that number 4 and that million number would mean anything.
At least that I could ascertain, no.
Okay.
And we did go to the website, and we attached the website in the lower court
Okay.
record as well, so.
Thank you.
So what the interesting, if you keep that open right there, it's interesting because they note in there, they have provided us with a summary of the information that we're seeking. Well, how can you, and then they claim later on, we don't have that data, right? And that was the initial
They say
argument.
it's not done yet for that calendar year.
It's not done for the totals that they're looking for. We're not looking for the totals. We want the base underlying data itself. So what we should have gotten was a big spreadsheet or a printout that says, just not, citation after citation of, on this date and at this time, officer whoever accessed the CPL database for this particular reason. And there should just be there's going to be a lot of them undoubtedly, but that they want the access to find out, and reason being is my client is an advocacy group for open carry. They're looking to understand what the law enforcement community is using the confidential CPL database for as part of going forward. So that's the important part here is that, initially they said we given you some numbers. Okay, now those numbers might correlate to the number of times to something else. They didn't produce that. And as I went to the website itself, it doesn't tell me anything anyways. And frankly, even if we address those numbers as being something, those are not the underlying data points. They're not looking for a total. If you look at the request, it's not asking for the total number of something. They want the actual base data because they want to do their own analysis on this. Okay. Now switching gears, that's my client's main thrust is they want that data, and it's our position that the trial court below in arguing that and concluding that this was, that by simply conduiting through lien, that this somehow the lien act applies. It doesn't. It's the firearms database is what actually applies, and there's no confidentiality for this 5E data, this individual reasons why you access the database. And we would ask the court to order that to be produced in due course. Now, the other two issues, of course, are important to my clients, but they're more important, of course, they're important, however, I find them more interesting being the fact that I do a lot of FOIA, and I don't think I've been before you on FOIA, but I know I've been before the both of you on FOIA. There's two other
How many
ancillary.
times?
I'm sorry?
How many times? Where can we find out?
We'd like to.
Oh, easily. I know at least one with yours, and I'm probably 2 or 3 with you. But that being said, the two other issues I think are important. That this case presents a perfect vehicle to answer who has to respond to the administrative appeals to the head of the agency. This position of the state is that we can delegate that authority to somebody else. The statute does not authorize delegation. And frankly, if the position was it was implied, you can't read an implication to a statute, especially when the FOIA coordinator, they gave delegation authority under Section 6 to the FOIA coordinator. So
What about something a little, I think it might be slightly different than delegation, would be a designee. I've certainly worked in organizations where I have been a designee, where I'm signing things that are, that I am the agent of the designor. I mean, at some point, you have to see, or I hope you can see that having the heads of departments responding to FOIA would be time-consuming.
But to be clear, and I think this is and I don't want to accuse my opposing counsel of misdirection, we're not asking him to decide FOIA requests. We're asking him to decide FOIA appeals.
Okay.
Okay? And so
Do you have
there's
any idea how many appeals?
a handful. I'm actually involved with litigation in the Court of Claims right now, trying to get access to that information, and I've been denied that information as well. So I was hoping to have something here that I could, flag around to you guys here today, but I can tell you, my own experience being a FOIA lawyer in this, it can't be more than a dozen a year for
Okay.
an agency.
Per agency.
Per agency.
27 agencies.
I know you came from military affairs. I'm
did.
sure you didn't see any in military
We never
affairs.
saw any FOIAs.
Yes.
Ever.
So,
Well, and I think you make these arguments
Saw
in your
lots of
brief pretty clear.
and I did. And the other last thing I would leave you with, I want to be clear about, is that I'm not saying that the head of the agency can't get help from somebody, right? But the ultimate decision, which the record in this case shows that the decision was never made by the colonel here, the head of the agency at the time under Snyder. It was made specifically by the designee. Now, what I'm arguing is that the designee could assist the head of the agency in saying, here's the facts, here's the details, here's my recommendation. The head of the agency could say, I agree with that, stamp it. That never occurred here on this particular record. And it's a very carefully constructed record to raise that issue before you here today.
Okay.
Lastly, my last point is that I am, again, swinging at the fences with my challenge to residential ratepayer. I will acknowledge, at minimum, I'm trying to preserve it if I have to take this case higher on this. I have been fighting against residential ratepayer since I started becoming a FOIA lawyer a decade ago. It is a bad decision. And the decision is a pre-1990 decision, so I don't think you're bound by it. Now, I'll be the first to admit, in fact, one of the cases is one I argued before on it, is that other courts have followed residential ratepayer, but they haven't analyzed whether or not it was correctly decided.
You want us to declare a conflict panel?
I either want you to say you don't have to follow residential ratepayer because it's a pre-1990, or declare a conflict panel if you think you're bound by it, because of the subsequent decisions. I'm not going to get into why I think I don't want to go into tremendous detail, but the problem is from a practical aspect, and I guess I speak to you as lawyer, from one lawyer to another lawyer, you guys all have had clients in your day, I'm sure. You have a client that comes in and says, I was denied access to this record for this particular reason. Okay, this is wrong. This is not supported by the law. This is not whatever, right? We bring a lawsuit. I'll tell you, out of probably more than half of my FOIA lawsuits that I bring, the reason why they assert the exemption in the initial letter is not the one they ultimately use when they get to court. That is costly, that is unfair, and most of the clients that I represent are individual citizens who can't afford fighting $20,000 of litigation's time to be able to fight new exemptions that their lawyers make up after the fact. I would advocate for the strongest terms possible that we in this state, we abide by and have a long tradition of raise it or waive it going forward. There is no reason why that should not apply to FOIA exemptions, especially when the statute under subsection 5 or section 5 of FOIA says the FOIA coordinator's decision is the final determination. If you allow for new exemptions on appeal, it's not final anymore. It's all up to the attorney, and normally, and Brother Counsel and I have been on the opposite tables many a time on this, and I give him a lot of credit. He comes up with new creative ideas at the trial court level. That's wrong. You should have to raise those in the beginning, otherwise you waive them, just like any of the appeals that come before you here as part of your process.
Okay.
Unless the court has any other questions, I sincerely appreciate your time this morning as usual.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. Assistant Attorney General Adam DeBear here on behalf of the Department of State Police. Now, I'm going to go through as best as I can, issue by issue, with the arguments raised by Open Carry. But as to the first one, whether the requested information was exempt from disclosure under the FOIA, I'm going to point one thing out. Opposing counsel indicated that the data they're seeking is not lean data. That's not the representation that the state police is making to the court. The representation that the state police is making to this court is that the data is something governed by the CJIS Policy Council Act, which governs criminal justice information systems, which is exactly the type of information that's at issue. The Law Enforcement Information Network is a network that can access a bunch of different information systems. And the information system issue at here is the CPL database and the CPL program application. So we're not making the case that it's lean data. Now, as to the records that, and I was debating whether or not to go into the detail about what sort of the statutory background behind these exemptions, but just for clarification purposes, one of exactly what open carry was requesting, we've since been able to determine was in MCL 28.421B sub 2 sub F. And that is what I call as the catch-all reason for accessing firearms records. And when you use the catch-all exemption, which is the officer reasonably believes it's necessary in the course of his or her duties, you have to input a specific reason into the lien system or whatever system you're using to access the information. And in that information system, the CPL database, that specific reason is stored. So what open carry is requesting was every individual entry, the specific reason that the law enforcement officer had to type in when they access the records under MCL 28.421B sub 2 sub F. Now, open carry references firearms records as being confidential, and he makes the point that he wasn't seeking firearms records. Firearms records are confidential under this statute, but essentially the statute is a codification of the Supreme Court's ruling in Mager versus the state police, I believe. At issue there were information related to gun owners' records, and the Supreme Court determined that gun owners' records were exempt from disclosure under the privacy statute.
But as I understand counsel's briefs and oral argument, the requester is not requesting the identity of any firearms owner anywhere, but simply saying, if a law enforcement officer access this database under the B2F provision, tell us who it was, when it was, and why they did it. I think that's what they were asking for.
Correct. And I just wanted to just draw the distinction between what the firearms records are and what the records that open carry was requesting are. And you're right, open carry wants the reasons for why the database was accessed under B2F and the name and the identity of the officers who did that.
Why is that not required to be produced?
Well, first of all, the exemption that that the state police used was 13.1D. Generally speaking, FOIA exemptions are permissive. When you go to 13.1D and you have to reference other statutes, the CJIS Policy Council Act in particular, it's mandatory. Disclosure is prohibited by the CJIS Policy Council Act. The state police has no discretion to raise the exemption or to not raise the exemption. And the CJIS Policy Council Act says that information governed under this act, the CJIS Policy Council Act, shall not be disclosed to the public except as authorized by law or by rule. Open carry identified no law or rule that identifies disclosure. And regarding the question of whether the FOIA itself is an authorizing law, Judge Redford, you made the appropriate points. There's a bunch of other statutes, including the ones with the state disbursement unit, all the information related to child support recipients and payees, again, has that type of statute. So the FOIA, which is a general pro-disclosure statute, can overweigh specific statutes that reference specific types of information and prohibit disclosure.
So if your client was prohibited from providing any information on this topic or on this subject, then what were those 7 numbers?
Well, that's a good question, and the answer is those 7 numbers come from the Firearms Act, an instance where the information is authorized by law to be disclosed. And I believe the statutory citation is in MCL 28.425E sub 5, and that's the section of the Firearms Act that requires the MSP to publish a report to the legislature regarding a number of different categories, as well as make it available on their website. And if you go down into E sub 5 sub O, one of that category deals with the number of times the database was accessed. And so that's what we provided him. In the request, open carry requested non-confidential information. And we provided them the non-confidential information.
So what is the 1, the 2, the 3 through 7? What does that refer to?
I did flag in the appendix, and I forgot to mention it, so thanks for asking that question. Plaintiff included the state police's response to interrogatories in the appendix, and the appendix citation is 44A and 45A, for your honor's information. So the numbers do refer to the categories. The only reason that they don't line up directly is that I believe it was number 5 and number 7 are really combined, and they're both number 5. So admittedly, when you line up these 7 numbers to the report has 6 numbers.
So, I mean, I know if I had received this letter, I would have found it incredibly unhelpful. And there's no reason why your client couldn't have provided a little bit more information so that it wasn't just a list of numbers that didn't seem to line up with anything, and then if you actually go to the website, it doesn't actually line up because it's 6 versus 7. But
To that point, I believe 5 of the 6 numbers do line up. And if you recall from reading the lower court record, one of the arguments advanced by the state police was that the records weren't sufficiently described in a manner that allowed the state police to locate what they were requesting. That argument was denied, but the Court of Claims agreed that the description of the requested records was clearer in litigation than it was in the FOIA request itself. So that would be my response to Your Honor's question. Now, just with regards to the whole issue of whether or not this is exempt from disclosure, the language in the CJIS Policy Council Act, specifically MCL 28.214 sub 5, that language where it says shall not be disclosed unless authorized by law or statute, like the Court of Claims said, is sufficient to trigger 13(1)D's application and render the requested information exempt from disclosure.
okay.
As to the second issue, the Court of Claims recognized that the FOIA does allow public bodies to take reasonable steps necessary to prevent interference with their duties. And the state police, as the lower court record shows, gets approximately, and this is combined with subpoena requests, but all records requests are about 20,000 per year for the state police.
How many FOIA appeals?
Certainly it's more than 12 for the state police, but to be clear, that's not in the record, and I don't know that information off the top of my head. It may or may not be thousands, but I would speculate that it's at least in the hundreds of appeals. And the point is, the state police, like other departments in the state of Michigan, the then director did delegate to Lori Hinckley the role of serving as appeals officer.
Is this a delegation just kind of an informal delegation through an org chart, or is there an actual document that the person becomes an official designee?
There is a writing, but it's not in the record, if that answers your question.
I guess I just wanted to know in general.
Yeah. And with regards to your earlier questions about whether the appropriate term is delegation or designee, I don't have an appropriate answer for that other than to have the director of the state police respond to whatever number of these appeals come in through the FOIA personally, without the assistance of another staff member, would interfere with the director of the state police's other duties, which are certainly important.
But to opposing counsel's point, regardless of whether it practically makes sense or not, the statute says department head, and I think I've come across statutory language that has said, the head of the department or their designee. I mean, I know there's places in statute that identify a designee.
The state administrative board is constituted by the governor, the attorney general, secretary of state, and other individuals. And it specifically says, and they shall be the members or their designee. So when the legislature has chosen to have executive officers to have the capacity to designate someone to do things for them, they've said it.
You're correct, Your Honor. That language is absent from the FOIA statute. And I have two responses to that point. First being, if we were to interpret the FOIA in a way that would prohibit the directors of these large state bodies to take these steps, it would render 15-233 sub 3 nugatory and superfluous. And I don't think that it would be something that the legislature intended to have the director of the state police, the Department of Environmental Equality, now EGLE, the Department of Health and Human Services, those directors personally responding to all of these FOIA requests. And in fact, again, the FOIA does.
Not FOIA requests, FOIA appeals.
FOIA appeals, I apologize.
No, big difference.
Correct.
Having
correct.
been an agency director, I can tell you it's a big difference.
Correct, Your Honor.
Well, and let's assume that I don't memorize statute numbers. What is the substance of the statute that you argue would be superfluous?
It was cited by the Court of Claims in its opinion and order, and I do have it printed here. It is MCL 15.233 sub 3, and it allows a public body to take steps that are, and here comes the quote, open quotations, necessary to prevent excessive and unreasonable interference with the discharge of its functions, period, close quote.
Okay, so you believe if we read department head to mean department head and not a designee, that would somehow make that entire phrase superfluous for all purposes?
In this particular instance, if the court finds in favor of open carry, then it would render this provision superfluous, particularly with respect to the Michigan State Police.
Okay, but that phrase could have operative meaning outside of the context of whether the department head can make a designee for appeals purposes.
Yes, and what happened in this case was there was a written designation or delegation, and the appeal was responded under the authority of this appeal was responded to under the authority of the director of the state police.
Okay.
With the with the director's acquiescence. And the second point to that issue is
And on the director's letterhead.
right. And the second point is the FOIA allows requesting persons to do two things. It provides for two remedies. One, you can commence a civil action to compel disclosure of the public records. That's what open carry did. That's why we're here today. And the other is you can commence a civil action to challenge the reasonableness of assessed fees. That's it. There's only two options. There is no mechanism under the FOIA to challenge this particular
So even
issue.
if you violated that provision, they got the remedy that they were entitled to? is your
Right,
position?
they're here today.
Okay.
And lastly, I know it is binding case law, but I just, with regards to residential ratepayer and the ability of the public bodies to raise exemptions for the first time in litigation, a good example of the reason why it is a good idea as opposed to a bad idea is found in Evening News, the preeminent FOIA case decided by the Supreme Court in the 80s. In that case, the Supreme Court indicated that the trial court judge is sort of the last step in determining whether or not the information is disclosed or exempted from disclosure. And before that order is made, the trial court has to conduct a particularized review of all the records and information at issue subject to disclosure. Now, if this were the instance of the Department of Health and Human Services, this is a bit speculative here, but I'm sure that they have information that would be subject to patient-client privilege or one of the other mental health-related privileges. If the department's FOIA coordinator failed to invoke the 13.1G or 13.1H, whatever that particular exemption is, of course it has to be raised again in litigation. And even if it's not raised in litigation in the affirmative defenses, the trial court judge would have another obligation to look at it to decide whether it should go out or it shouldn't go out. That privilege in those particular exemptions is not the department's to waive. So just that's one of the good reasons why residential ratepayer and the ability to raise exemptions and affirmative defenses is a good idea. It's different from other cases. There's an administrative level and then a trial court de novo review. And so the ability to raise affirmative defenses, as opposing counsel argued, is binding and established not only in residential ratepayer but in Stone Street Capital, a 2004 Michigan Court of Appeals case, and also in Bitterman versus Village of Oakley, a 2015 Michigan Court of Appeals case.
All right, thank you.
Thanks, Your Honors.
Brief rebuttal?
He is correct about Bitterman versus Village of Oakley because I was the counsel on Bitterman for Village of Oakley as well. So I've been fighting this residential ratepayer for what, 8 years now? That's not 8 years. I want to bring up one point in response very briefly. I respectfully but vehemently disagree with my co-counsel about his citation to the Criminal Justice Act. And it says that the public can't be accessed at, that's not what the statute says. The statute's very careful here, and they breeze over it, but it's the only basis that serves as their exemption because I didn't hear a single citation to the Firearms Act as being the basis to deny access to the 5E data or the 4BF data. Subsection, it's 28.214, subsection 5, and I want to read it because it's very, very important. It says, a person shall not disclose information governed under this act in a manner that is not authorized by law or rule. It doesn't prohibit disclosure. It doesn't, because again, section 13.1D says it has to be specifically identified and exempted. It says it prohibits that you can't do it in any manner that is not authorized by law or rule. So what that's saying is that, I think what this is saying is that you can't do a Rockford and a Dennis. And I don't know if you remember in Rockford, Jim Rockford would always call his buddy Dennis at the police department and say, run this through the computer and find out whose license plate this is, or run this person and see if they have a CPL, right? I got a 2-year-old. We have late nights with these kinds of things now, right? It's on Prime these days. So, what that act is saying is Dennis, the police officer, the detective, you can't just hand out stuff to your buddy. You can only use it in a manner that is authorized by law or rule. The manner here is FOIA. It's not that FOIA overrides, it's that it's a set process, a manner by which they can respond. It's not a prohibition on access to records. And to the extent that they would rely on their own administrative rule that they passed, the statute is specifically clear that it only applies to statutes. And this court has already dealt with that issue in Detroit Free Press versus City of Warren. I cite that in the brief, but I'll just for the record, it's 250 Mishap 164. An administrative rule cannot serve as a basis for an exemption under the 13(1)D pass-through at all. It has to be by statute, and the statute is the only basis going forward. So I would, while I'm not going to, cast aspersions on my brother counsel, because we're going to be at it with each other again in the future. His reading of the statute is flimsy to try to get the result he's looking for, rather than the specific language that's there. And I would ask the court to look at that carefully. Okay. Unless the court has any other questions, we sincerely appreciate your time today.
Thank you both.
Really
Thank you.
excellent, well done. Thank you very much.
The case is submitted.